for just double checking, Chair.
Sure.
That's all. Yes.
You're good. Sure, no.
We're good.
All right, thank you. We're now in executive session and we'll look at the executive session consent calendar. Items 21 through 26. I understand that we can accept a motion and vote on those right away, correct?
Yes, and these were all public meeting law complaints that were filed, but didn't show that they had met those mandatory prerequisites. So they are up for dismissal.
Perfect. Thank you. Chair Fiscum, I'm happy to receive a motion on the consent, adopting the consent calendar.
Thank you, Mr. Chair. Let me just make one quick comment. I apologize to the assembled persons that I'm only on the phone today. The reason is that vandals struck the fiber optics in my area, making the internet unavailable from about a radius of at least 5 or 10 miles, and it might be restored before the meeting is over. But for that reason, I'm on the phone only. I just wanted to make that clarification and with my apology. That said, I will move the commission approve the consent calendar for the executive session as presented on the January 5th, 2024 meeting. Thank you.
Thank you. Thank you, commissioners. Any comments? Hearing none, we'll call for the vote.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Mitoli,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. We'll now move on to agenda item 27, correct? And regarding Elaine Bryson. And Investigator Marietta will report on that, and let's make sure that Miss Bryson is, or her attorney, it sounds like, will be attending.
Looks like they're both here.
Here.
And Elaine Bryson is here.
All right, thank you. Good morning, Miss Bryson. This is Sean Lindsay. I'm chair of the commission. What we're going to do now is consider your case, and procedurally how this is going to happen is our investigator is going to provide a report on your matter. Number one. Number two, the commissioners will have an opportunity to ask questions. After that, you or your attorney will be given the opportunity to respond. We ask that we do have a heavy agenda today, so we ask that you be efficient with your time. Commissioners will have a chance to ask you questions, and then we'll make a decision whether or not to proceed additionally with additional investigation or not. Either way, we're not making a final decision on the merits of the case today. All right, Investigator Marietta.
Great. Thank you, Chair. Commissioners, this is Investigator Hillary Marietta. Agenda item 27 is a preliminary review report for Elaine Bryson, a school board member for the Lane County School District 68, also known as McKenzie School District. The complaint in this case alleges that Elaine Bryson voted on a memorandum of agreement that included a 38.33 pay increase for her son, an education assistant. In her response to commission staff, Ms. Bryson stated she believed she had a class exception. Ms. Bryson submitted a copy of the MOA between McKenzie School District and Oregon School Employees Association, or OC. The MOA agreed to an additional 4% COLA beyond the 2% currently in the 2023 to 2024 pay schedule. The combination of the instructional behavioral educational assistant and educational assistant job classification positions reflecting use of all education assistants supporting students' behavioral needs. The position will henceforth be called educational assistant and will use the instructional behavioral educational assistant pay scale. Commission staff followed up with Ms. Bryson to confirm whether or not her son got reclassified to the instructional behavioral educational assistant pay scale, and she confirmed that he did. At the July 19th board meeting, Ms. Bryson did not announce a conflict of interest and voted to approve the MOA. In this case, Ms. Bryson's son was affected to a different degree than the rest of the staff. Specifically, he and other EAs constituted a subset of the district staff who were reclassified to a different pay scale with an increase that exceeded the 6% that would be received by the majority of district staff. So it does not appear that he has a class exception. Because of this, the recommendation in your books is to move this case to investigation.
Thank you. Commissioners, any question for Investigator Marietta? Okay, seeing none. Mr. King, will you be speaking for Ms. Bryson or will?
Yes, I plan on speaking for Ms. Bryson this morning.
Okay, go ahead. Thank you.
Thank you, and good morning. I'll just make a quick statement, but Ms. Bryson is she's a longtime resident of Vida, Oregon. She worked in the McKenzie School District for many years before retiring. She now serves the district by serving on the board, and her son currently works for the school district. You should know this district is very small. There are only about, I believe, 15 certified staff working as teachers and 25 classified staff. They work in various roles, and they serve roughly 186 students, I believe, at last count. It's a small community. Everybody knows each other. All the board members are aware of and familiar with each other's families and who works for the district. With respect to the agreement voted on by the board, Ms. Bryson knew that her son was employed by the district. She didn't know whether he was an educational assistant or an instructional behavioral educational assistant. It was Ms. Bryson's understanding that the class exception would apply. If you take the educational assistants and the instructional behavioral ones together, it's almost half of the classified staff. At the time the vote was taken, only 3 of the 25 classified staff were educational assistants, but Ms. Bryson's actions were only made in good faith. I also want to add just a little bit of context before I finish. It was a unanimous vote on something the district had already been planning. In this case, in April of that year, only a couple months before, 2 of the educational assistants had already been made instructional behavior educational assistants, and that was sort of a move they were planning. They were consolidating those 2 roles into one role, one category, and so the district also basically this vote was just finalizing that process. And while Ms. Bryson hopes that the commission will dismiss the complaint, she wants to let you know also that she intends to fully cooperate with any investigation. And thank you for your time.
Thank you. Thank you, Mr. King. Commissioners, any questions for Mr. King or Ms. Bryson? Okay, seeing none, is there a commissioner prepared to make a motion on how to proceed?
Mr. Chair, this is Vice Chair Fiska. Just a quick question, and I'm prepared to make a motion if you would like.
Go for it.
Ms. Marietta, could you just quickly summarize for us again what it was you would look at if we move forward to conduct an investigation? What specifically would you be looking at? Thank you.
Yeah, of course. To be honest, I don't really think that there's much more I need to look into. Maybe the next step, depending on, the executive director's approval, would be possibly to offer Ms. Bryson a letter of education to better understand the statutes and the requirements.
Thank you, Ms. Marietta. And just to reiterate, just ask one further question. My understanding of our process after these years of me being involved in it is that we are not free to vote for a letter of education today. That would be the next step should we move to, quote, investigate, unquote. Am I right in that?
Correct. Yes, correct. You would
Thank
have to move it forward. Yeah.
Thank you. Mr. Chair, I'm prepared to make a motion. This is Commissioner Fisk. I'm prepared to make a motion if you're ready.
Ready.
Thank you. I hereby move that the commission find there is a substantial objective basis for believing that Elaine Bryson may have violated ORS 244.120 sub 4 and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, any comments on the motion that's on the table?
Yeah. I think what we're looking at is 244-120. There's no sub 4 here. The 4 is actually the number of the motion in your book. So I just want to be clear.
Pardon
We're
me.
just looking at 244-120.
Pardon me, the replacement motion will remove the number 4. Thank you very much.
Sorry about that.
Thank you. Any comments on the motion? All right, seeing none, we'll go ahead and call the vote.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell.
Aye.
Chair Lindsay,
Aye.
motion passes 9-0.
Hey, thank you. Ms. Bryson, Mr. King, thank you for being here today. What's happened is we have not made a decision that you've violated anything. We've simply made a decision to proceed beyond the preliminary review. And I think you've heard what the likely outcome will be, and we appreciate you being with us today.
Thank you.
Thank you very much.
Thank you. We'll wait for them to leave, and then I understand our agenda items 28 through 32, are those?
Yeah, Chair, we have somebody on the line that their caller ID is blocked. Can we just maybe bring them in and ask them who they are? And
Yeah, can we do that, please?
Of course.
Sure. Are they in?
they're admitting right now.
Hi there. We see a phone number here at 266-696-68 something something. Could you please identify yourself?
Chair, that number is what appears when a caller ID is blocked, so they're not going to recognize that number. So it'd be
Right.
the individual that was just admitted from the waiting room.
Yeah, someone was just admitted to the from the waiting room into this executive meeting, and they have caller ID on their phone. Could you please identify who you are?
Okay,
Let's see.
nice try.
Yeah, can we just remove them?
Yeah.
Okay.
Give them a try.
All right, thank you.
Sorry about that.
All right, agenda items 28 through 32, is that correct? Are we gonna hear them together?
Yes.
Okay,
Just 1 minute, we're admitting
Sure.
the one respondent that's.
Let's see.
well, only one respondent is attending for those. And which one is that?
It is Michaela Demeter.
Okay. Hi, Ms. Demeter, are you in this meeting? Can you hear us? Ms. Demeter? Michaela?
She's currently muted, Chair.
Yeah, it looks like you're muted. Are you able to take your mute off so you can hear us? Yeah. All right, well, we cannot hear you. Trust that you can hear us.
Now,
Ms. Demeter.
now can you
There-
hear me?
We can hear you now. Thank you. Welcome to our meeting.
Okay, yeah,
This is the opportunity to have your case heard. What's going to happen here is Investigator Walker is going to be reporting on your case alongside the other complaint matters, and she's going to report on that to the commission. And then you will have an opportunity, a brief opportunity to respond, to share your side. It is a heavy agenda today, so we ask that you be precise and efficient with your time. And we might have some questions for you, and then we'll make a decision as to what to do after this preliminary review, whether to dismiss or to move on with additional investigation. So that's the purpose of this moment. And we'll turn the time over to Investigator Walker.
Thank you, Chair Lindsay and Commissioners. For the record, this is Monica Walker, investigator for the Commission. Item numbers 28 through 32 in your reading books are preliminary review reports for the 5 Commission members of the Vernonia Rural Fire Protection District, herein called District. As all respondents have provided a confidentiality waiver and their cases are the same, with the chair's permission, I will present these cases together.
Permission granted.
Thank you. The complaint in these matters concerns 3 out of 4 executive sessions held by the district on September 12th of 2023. The complaint, which was filed by the current fire chief, alleges that the district may have participated in unauthorized executive sessions by discussing topics that did not correspond to the statutory authority cited. Additionally, the district may have failed to properly announce or cite the reason for entering into one of the executive sessions prior to that session being held, and may also have made a final decision while still in executive session. This preliminary review was open to determine if the respondents violated the executive session provisions of public meetings law. In staff's review of the meeting materials and documentation received, it appears that in the case of session 1, the district discussed the contract of the current fire chief, Rob Davis. The district members appeared to have discussed the compensation and benefits included within the fire chief's contract. This discussion appears to have exceeded the scope permitted and would therefore not be authorized under the provision which was cited, which was ORS 192660, subsection 2, subsection I, which authorizes a governing body to hold an executive session to review and evaluate the job performance of a chief executive officer, other officers, employees, and staff if the person whose performance is being reviewed and evaluated does not request an open hearing. During the preliminary review, staff confirmed with Chief Davis that although in attendance during the executive session, he never received an actual written notice giving him the opportunity to request that the matter be heard in an open hearing. For session 2, the district again cited ORS 192660, subsection 2, subsection 1, to discuss the status of a previously filed ethics complaint against the former fire chief. As noted previously, subsection 2I authorizes a governing body to hold an executive session to review and evaluate the job performance of a chief executive officer or an employee, etc. As the discussion concerned the former fire chief, who was no longer employed by the district, it is not a topic of discussion that would be authorized for an executive session cited under subsection 2I. In review of the third session mentioned in the complaint, the district appears to have failed to provide notice on the agenda that was posted for the public and interested parties. Additionally, the session was not publicly announced prior to entering into executive session. Rather, it appears to have been added by the presiding officer during the executive session meeting itself. Thus, it appears this was not a proper convening of an executive session cited under subsection 2F, which allows a governing body to consider information and records exempt from public disclosure. During this session, the district appears to have discussed an anonymous complaint filed against Fire Chief Rob Davis under subsection 2F per direction of the district legal counsel. By not properly announcing the basis for entering into executive session prior to convening the executive session, it appears the district violated the provisions of executive session. Lastly, the complaint alleges the district made a final decision while in executive session, as the district did not provide a synopsis and no information on the executive session was shared upon reconvening regular session and adjourning the meeting. But 5 days after the session was held, the fire chief was placed on administrative leave. Per the response received, however, it appears the district chair, Michaela Demeter, who is allowed to work with the district attorney and speak on behalf of the district, initiated a letter of paid administrative leave pending an internal investigation in consultation with the district attorney in the days after the executive session was held. As the information gained is contradictory, should this matter be moved to investigation, commission staff would interview district members to fill in the gaps and determine whether a final decision was reached in executive session. Based on the information gathered, it appears the district may not have satisfied all necessary prerequisites, may have exceeded the scope of any authorization, discussed matters not authorized by cited statutory authority, and may have reached a final decision while in executive session, while in the executive sessions held on September 12th of 2023. Therefore, the report in your meeting books recommends moving these cases to investigation.
Thank you.
Thank you.
Commission, any questions for Investigator Walker? Commissioner Fiska?
No questions. Thank you very much.
Thank you.
Do we have somebody prepared to testify, Chair?
Yes, we do. We have Mr. Meter on the phone. Mr. Meter, it is now your opportunity to share your thoughts with us. And again, we ask that you be precise and efficient with the time, and we look forward to hearing your comments.
Okay, so let's start off with first there were actually 3 executive sessions and then 1 that was added by me. So there was a 192-6602I that was reporting on the previous chief, which I stopped because the information that was being given was not public information and was not supposed to, that we shouldn't have been heard. Okay, so I actually basically stopped Acting Chief Davis while we were in that session. We moved on to the next session, which was about Acting Chief Davis's contract. Now, I don't feel that it was necessary for us to give him in writing the ability to have it in public session when he made the request directly in writing to the board that we have this in executive session. And that email can be provided. It was dated in August, and I will actually read to you what it says. He says here, I am requesting an executive session to review my performance and to make contract amendment at the next meeting. The amendment is in regards to wages and pay. Currently, the district is behind $11,175 in contractual payments. I will be requesting that the district pay this amount out in one lump sum and the contract amendment to ensure that this is no longer an issue. The amount owed was in deferred compensation and HSA, which were never set up from the previous chief. This seems to be an impossible task, and I will be requesting the board accept contract change to remove these added benefits and exchange them for straight wages. This will make my wages equal to what my wages and added benefits were in my contract, plus my fire chief incentive, or in shorter terms, equal to the amount budgeted for my position. It will be much easier explained in person. Just want you to know that it's coming. So I feel the fact that it was given to us in written form, that he wanted this in executive session, we didn't need to give it to him, give him written information that he could have this in open session when he could have put this directly onto our agenda to begin with. The next one was a purely informational one, which was 192-660 subsection 2, subsection K, which was about a school safety program that was being brought to us, and that was handled normally. Now, we move into the one in question, which is I had received earlier that day, the day of the board meeting, a letter that contained extremely serious allegations about the acting chief that directly related to the safety of our volunteers and of our paid staff. I immediately contacted council, asked council to start the process for an administrative leave letter because I knew that we were going to be doing this anyway. I asked if we could please have her available to speak during an executive session that I would have to call that night so that any of the other board members could ask any questions that they needed over and above what I could answer. At the board meeting, we contacted council after the first 3 sessions. Council said that we should definitely call this a 192-660 subsection 2 subsection, and I don't have that one, but it was basically contacting, discussion with council. We went through, they had their discussion, everything like that. Everything was fine. And we exited session. Now, this is where another problem lies, and this was my fault. I did not close all of the sessions correctly. I mean, there was so much going on. We had We had board members that wanted to fire the acting chief immediately. I'm telling them, no, we cannot do that. There has to be an internal investigation. We have, and things like that. So I'm trying to keep board members calm. I'm trying to keep other things going. And at the same time, make sure that none of this information is leaked to the public because of the fact that these were just allegations. We have no proof. So mistakes were made, yes. As far as the not being allowed to talk about wages and pay under 192.660 2I, we were not aware that you could not do that. I've been on the board of directors for the Vernonia Rural Fire Protection District for 9 years. The last year and a half, I've been the board chair. And this is what we have. I mean, this is a very poor excuse. This is what we have always done. And I will see that after going back and rereading all of 192.660, that we should probably have used 192.660 subsection 3 for discussion of wages and contract. So that's a mistake that's been perpetuated through the training. I've been there through 3 different board chairs. So, and this is the way that I was trained also. So yes, there were mistakes made. I don't feel that any of the mistakes gravitate towards an ethical violation at all. If you have any other questions, I'd be willing to answer them.
Thank you. We really appreciate your transparency and straightforwardness. I personally appreciate your efforts to try to do the right thing. And again, today is not a decision as to whether you have actually violated anything. It's just a decision whether to conduct additional investigation or not. Commissioners, any questions for Ms. Demeter, please? Any additional questions? Yeah, Commissioner Thompson.
Investigator Walker, we just heard that the chief or acting chief requested an executive session. Does that change anything as opposed to the giving him the option of executive or public session if he requests an executive session?
So the statute is clear in that they must be given that opportunity. It doesn't matter who requests to have it.
Okay.
It is incumbent upon the district or the board to ensure that the opportunity is given and those prerequisites are met.
Okay, thank you.
Thank you.
Thank you, Mr. Chair.
Thank you. Any other questions, commissioners? Commissioner Hollister has a question. And Ms. Demeter, we'll get back to you in a minute.
Hi, Chair.
Okay.
Thank you for the opportunity to ask a question. I suppose I have more of a statement or comment from my fellow commissioners. It does seem like this is one of those cases where if in fact the only thing at issue in the one executive session is whether or not the fire chief was provided notice, that does seem like sort of a technicality of a technicality. And I guess I just would like to suggest that maybe we have discretion not to move that piece forward. If we believe that everyone had the best intent, and in fact, the fire chief had actual notice in this case, since he requested the executive session at the specific meeting. I understand that the law requires something very formal. I'm not disagreeing with our investigator on that point, but I just wanted to point to the fact that in my opinion, we had discretion on that.
Okay, thank you. Executive Director Burson, did you want to make a comment?
Yeah, just a couple of things while the respondent's on the phone. First of all, I think all we're doing is looking at each one of these executive sessions and what actually happened in there can be, part of that investigation. And you're right. At that point, you can make it, your discretion to say, well, I think the best foot was forward. But the other problem with that same executive session is we're talking about salary, we're talking about contracts, and that is not allowed in an executive session. So I don't really want to get rid of an executive session, but maybe one of the issues when we come up to investigation may be able to have the commission's discretion to say, well, he requested it. So I think we're probably at least on better ground. The other thing, just what Ms. Demeter talked about was 192.660.3 is not what you should go in for. That's labor negotiations. I mean, that is not what you go into to talk to your chief executive officer on their salary. That is done in public, and you need to tell the public what you're going to pay your chief executive officer. So labor negotiations is basically when unions are negotiating labor. So I don't want them in the future using 192-6603 to talk about salaries for their chief executive officer of their district. So just to be really clear on that. So.
Okay.
Thank you.
Okay, so now,
Mr. Meter, hold
can I
on.
make a couple of things?
In just a
Okay.
minute, we have commissioners that still have some questions. I'll get back to you when we're ready. Thank you. Commissioner
Okay.
Burke. Thank you, Chair Lindsay. Speaking to Commissioner Hollister's point, if we opt to move forward with an investigation and it comes back, we always have the option of dividing the question with respect to the alleged violations and which ones we'd want to pursue.
Okay, thank you. Commissioners, any other questions or comments? Chair Hollister or Commissioner Hollister. Best Chair Hollister.
Thank you, Chair. I just wanted to say that I agree with Commissioner Burke and I agree with Executive Director Burson's comments. I guess I just struggle at times with this notice requirement when it becomes beyond a technicality when you have an individual requesting it at a specific time and place. And I mean, I think that a lot of those requirements are based on our rule. And I start to wonder if our rule maybe went beyond the intent of the statute. So that's just my own personal thing. I know Ron looks like he's wanting to disagree with me. Maybe we should have a conversation offline on that.
No, I just want to point out, we have 3 separate executive sessions, and I think what you're talking about executive session number 1, and I think we can talk about that. But the one in which you receive information that you want to talk, or you may discipline your chief executive officer, and then you hold a meeting that night, you did not give that executive officer the chance to have that in public or to have it in private. So that third, is it the third one that was?
I believe it was actually the 4th one that was discussed, but
Okay.
the 3rd one
But
was.
you know, that kind of emergency meeting, like I got some information, we're going to bring it to the board, and we're actually going to make a decision on whether or not we're going to keep this person or not. That is really what that rule is about, is that person that is going to be disciplined underneath that 2I, that they have the opportunity to choose whether to have it in public or private. And I think that happened very quickly. And I don't think the chief was given the opportunity, but I think that'll be found out in investigation at this point. Again, we've just got a 60-day review. So I kind of looked at when I read this, I looked at each one of those as kind of separate acts. And you may be right on the first act. I mean, I think that, yeah, we could probably be lenient there. But when you got to that one, yeah, I mean, you're actually, I think even the chair here for the district had said he had, or she had board members that wanted to fire the chief at that meeting, and they had not been noticed beforehand that there was going to be a disciplinary hearing on them. So.
Got it. Thank you. Mr. Meter, now's your chance just to have a couple brief reply.
Okay, quick brief reply on the contract discussions. This was not a wage discussion. This was a contract change discussion. Now, I don't know where you talk about contracts under the 192-660 statute. This was purely to discuss and get things changed. No decisions are made there. I mean, no, we always make these decisions for the contract in public. Contract is public knowledge, and we always do that after we come out of the board session, after we come out of the executive session. So no decisions are made, nothing is voted in, nothing is done until we do it in public.
Okay.
And all of that information is available to the public. Now on the second one, which is the one, it was not actually to discipline or do anything with the chief. It was to discuss with the attorney the process that I had already begun. I spoke to district council earlier in the day and asked her to prepare and start getting everything ready for an administrative leave notice to Acting Chief Davis. I had the session there so that, number one, we could bring to light that information and have the attorney answer any questions that any of our other board members had over the action that I was taking. The reason that it was taken with in that way is because the attorney had told me that we want to make sure that evidence is not destroyed, people are not were not put into a place where they felt they were pressured or anything like that. And so we wanted to keep this quiet. We did not want this to be public because, once again, they're only allegations. And so putting something like that in public would have put the district in a very bad place if it turns out that these allegations were false. So we were working on something to make sure that the acting chief's reputation was spared, and at the same time trying to protect the district from anything that could happen based on these allegations.
Thank you. We appreciate your comments. All right, board, I think we have a decision to make here. I'll just make a statement here. I think there's enough hair on this that needs to be ironed out and corrected and make sure it's done correctly. And so I think it's appropriate to proceed forward. Personally, that's how I'm inclined to vote, is to proceed forward with investigating possible violations. That said, I'll ask for a motion if any commissioner is prepared to make a motion.
Mr. Chair, this is Commissioner Fiscom. I'm prepared to make a motion, but I'd be happy also at the same time to yield to my colleague, Commissioner Hollister, if she would prefer to make a motion in light of her involvement in this issue.
He's shaking her head no.
Okay, thank you very much. Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Michaela Demeter may have violated ORS 192.660 sub 2 and ORS 192.660 sub 6, and that the commission should investigate accordingly.
Thank you. Commissioners, comments on the motion? Hearing none, we'll call for the vote. Hold on. Sorry.
I just want to comment really specifically. So just to be specific, my only issue is with the interpretation of ORS 192.660 sub 2 sub I. I think in that instance where the statute says that the person whose performance is being reviewed and evaluated does not request an open hearing, and we have a letter from the person saying want an executive session, I think it would be relevant for the commission to consider that fact down the line. I agree that this case needs further investigation. My concern is with the legal interpretation of that statute, period. So,
I see staff nodding their head, and I think that's duly noted. Thank you, Hollister. All right, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Burke, oh, thumbs up. Okay, his audio's off again. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Chair Lindsay.
Aye.
Motion passed 9-0.
Thank you. Mr. Meter, as you've heard, we've just passed a motion to move to investigate possible violation. Again, it's not a decision as to an actual violation. It's just a decision to proceed further. And we appreciate your time with this. We'll now move on to agenda item 29. Commissioner Fiscom.
Chair, thank you. Is there anything else to be said? And the investigator's report stands as given previously, and therefore, Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that James Pisarski may have violated ORS 192.660 sub 2 and ORS 192.660 sub 6, and that the commission should investigate accordingly. Thank you.
Thank you. Commissioners, seeing no comments, we'll call for the vote.
Commissioner Fiscum,
Aye.
Commissioner Burt. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. Vice Chair Fiscum, agenda item 30.
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that James George may have violated ORS 192.660 sub 2 and ORS 192.660 sub 6, and that the commission should investigate accordingly. Thank you.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Burke. Thumbs up for aye. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister.
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. Chair Fiscum, agenda item 31.
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Neil Kennedy may have violated ORS 192.660 sub 2 and ORS 192.660 sub 6, and that the commission should investigate accordingly. Thank you.
Seeing no comments, please call for the vote.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. Thumbs up. Commissioner Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. And Vice Chair Fiscum, agenda item 32.
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Shelley Hess may have violated ORS 192.660 sub 2 and ORS 192.660 sub 6, and that the commission should investigate accordingly.
Thank you. Please call for the vote.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. Ms. Demeter, thank you for being with us today. We appreciate your comments and we'll be in touch. You have a good day. All right, we're moving on to agenda item 33, Mr. Steve Sims, is that correct?
Yes.
And it looks like he will be attending and
Please let us know that he will not be attending.
he will not be attending. Okay. So Investigator Marietta, go ahead.
All right, thank you, Chair. Commissioners, this is Investigator Hillary Marietta. Agenda item 33 is a preliminary review report for Steve Sims, a road division manager for Yamhill County. The complaint in this case alleges that Steve Sims used his official position to hire his father's trucking company. Steve Sims did not provide a response to commission staff. However, Mark Lago, the public works director for Yamhill County, provided a written response. Mark Lago writes that each year in May, he puts together a competitive bidding package. The county advertises the package across several mediums. Mr. Lago selects the bids and creates a tally list. Mr. Lago stated that Mr. Sims is not involved with any part of the call for bids process or final approval of the bid tally trucking list. He also submitted supporting documents with his written response, including the competitive quote package. The package indicates that the county intends to enter into binding contractual agreements with more than one vendor for contracting trucking services, and that Steve Sims, Yamhill County Road Supervisor, is the supervisor for these projects. When commission staff asked Mr. Lago who supervises Steve Sims Senior's trucking company, Mr. Lago indicated that the HEO manages the contract haulers and directs them on where to dump or load gravel, which is a job performed by Steve Sims Trucking. And I just want to add, I don't know what HEO is. I apologize. That is what was conveyed to me in the email. I would figure out what that is moving forward. What is it?
I wonder if it's heavy.
Oh, heavy equipment operator. Yes, that makes sense. Okay, thank you. While Mr. Lago provided this information to commission staff, the information in the quote package indicates that Steve Sims will supervise these projects. It also appears the HEOs directly report to Steve Sims. And further, the quote package does not feature any language or policy that specifies when a public official may directly supervise a relative. Should this case be moved to investigation, commission staff would seek to determine whether any such policy exists, or on the other hand, who is directly supervising Steve Sims Trucking during these projects he is completing for Yamhill County. Just at this time, additional information is needed to determine whether Mr. Sims is supervising his father. In addition, Mr. Lago indicated that Mr. Sims was not a part of the bid selection process. However, it is unclear whether he is a part of selecting from the tally list when work needs to be completed for the county. Again, additional information is needed to determine what companies are picked from these tally lists. There's presently no information to either indicate one way or the other. And finally, if Mr. Sims did perform these functions for the county related to his father's business, he would be met with a conflict of interest. Should this case be moved to investigation, commission staff would seek to determine whether he ever announced any conflict of interest to his appointing authority. The recommendation in your books is to move this case to investigation.
Thank you. Commissioners, any questions for Investigator Marietta? Seeing not, Vice Chair Fiscom, do you have a motion for us?
Yes, Mr. Chair, I do. Just a quick preamble. I want to thank our investigator for that, the precision of her report, which helps me to make the following motion. I hereby move that the commission find there is a substantial objective basis for believing that Steve Sims may have violated ORS 244.120 sub 1, ORS 2.244.040, and ORS 244.179, and that the commission should investigate accordingly.
Thank you. Commissioners, any comments on the current motion? Seeing none, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Burt, thumbs up, Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay,
Aye.
motion passes 9-0.
Thank you. Yes,
Learned.
the learned, that's
The learned.
coined terms for everybody. All right, we're moving on to agenda items 34 through 36. And I understand Mr. Sykes and will be attending via Teams and Mr. Drago via phone.
Mr. Chair, this is your vice chair. When the moment is right, I want to make a comment for the record. With your indulgence, you tell me when.
Or an executive session.
Yeah, we are in executive session, so is this just a fun comment?
Sort of.
Go for it.
Thank you, Mr. Chair. In view of the fact that issues involving Morrow County are on the Ethics Commission executive session agenda today, it is appropriate for me to make just a quick comment for the record. As some of you may remember, a complaint was lodged against me last year contending that, as I would describe it, I had failed to disclose a conflict of interest or recuse myself on issues involving Morrow County and or the Port of Morrow. After an official preliminary review, the complaint against me was dismissed when it was clear that I had no relationship with Morrow County or the Port of Morrow when I was registered as a lobbyist in the state of Oregon, and that is still true today. However, out of an overabundance of caution, I put this on the record to reiterate that I have no conflict of interest in Morrow County issues, and thus there is no need to declare such a conflict or recuse myself today. Mr. Chair and Commissioners, thank you.
Thank you. Executive Director Person.
Just to be clear, I mean, if this was an actual conflict of interest, he would need to declare that in the public session. But the commission had actually had a case and made a determination that he was not conflicted. And so again, I think that Commissioner Fiscum is doing this in kind of an overabundance of caution. And this will become a public record after the meeting today. But like I said, if there wasn't an actual conflict or a potential conflict, we would need to do that in public session.
Perfect. Thank you. Thank you,
Mr.
Vice Chair Fiscum.
Director Burson, I fully understand that. Thank you for that firm clarification. I would have followed that if there was a conflict. Thank you.
Thanks.
Thank you. Mr. Sykes, welcome. We appreciate you being here with us today. And Mr. Drago, are you on the line?
Yes, I am. Thank you.
Great. And I understand that Mr. Winholtz is not appearing. So thank you for being with us. This is the opportunity to have your case heard before the commission today. The way this is going to proceed forward is Investigator Myers is going to provide a report to the commission. The commission will have a chance to ask questions of her. Then you will have a brief opportunity to respond. We ask that your response or responses be precise and considering the heavy agenda that we have today. And after that, we'll make a decision as to what the next procedural steps will be. So, Investigator Myers.
Thank you, Chair Lindsay. Commissioners, for the record, this is Susan Myers. Items 34 to 36 are preliminary review reports for the 3 members of the Morrow County Commission. They all waived confidentiality, so I will consider the cases together. These cases involved an executive session held by the County Commission on April 19th. It was convened under ORS 192660, subsection 2E. This provision authorizes a governing body to meet in executive session to conduct deliberations with the person designated to negotiate real property transactions. Section 2E requires that they be deliberating with the designee, that there be negotiations of a real property transaction. Section 2E is silent as to who can serve as designee. In this case, it does appear that the designee was the board chair, along with other members of a committee formed to make recommendations to the board relating to potential locations for a new county courthouse. In the April 19th executive session, this committee appears to have reported on these potential locations. As the Attorney General's Public Records and Meetings Manual notes, Section 2E, subsection 2E does not authorize discussion of a public body's long-term space needs. Discussion of narrowing a selection of potential sites based on whether they satisfy the county's needs does not appear to be authorized under subsection 2E. Additionally, it appears there were no negotiations at the time of the April 19th meeting. Rather, they were simply regarding evaluating potential sites. That negotiations might be required in the future does not mean that the executive session would be authorized under subsection 2E. It also appears in this case that there never were any negotiations, as the board decided to locate the new courthouse on county property. There appears to be a substantial objective basis to believe that the executive session may not have been authorized. The reports in your meeting books recommend moving these matters to investigation.
Thank you. Commissioners, any comments for Investigator Myers? Commissioner Thompson.
Thank you for that, Investigator Myers. I guess where I'm hung up here is if we're talking about 3 or 4 sites and one of them meets space needs and the other 3 don't, and I'm the person that owns the one site, wouldn't that run the risk to the county that I would just raise, if that was public, that I would raise the price that I was offering that? So my concern is I guess around the definition of negotiation. If I'm telegraphing as the county commission that this site meets our needs better than these other sites, do I run the risk of?
I mean, I think it's a valid concern that the issue with subsection 2E is public bodies out there, governing bodies seem to think if anything falls under the term real estate, we can talk about it in executive session. And that's definitely not the case. In this case, yes, subsection 2E is designed to put public bodies on the same level as private bodies when it comes to real estate negotiations, so that they don't have to reveal their top or their bottom if they're their top if they're selling. But so I would need to look into whether at this April 19th meeting were all of the potential sites ones that were public, because my understanding is it was the county site, there were some city of Boardman sites, where the negotiations themselves would essentially be public. I mean, the city of Boardman had already identified the sites that it wanted to make available. So I think it is worth further inquiry, but I do see a point that if they were telegraphing to a private of the potential sites, a private seller, you would have an argument that that could potentially fall under negotiations.
Thank you.
Could I add one piece to that? So there are other exemptions, for instance, internal advisory communications, where there's a memo that's written that outlines from staff giving advice to the commission that there may be, or whatever body is meeting, there may be other justifications for meeting an executive session. But if they're not actually doing a real estate negotiation, then it wouldn't fall within the real estate negotiation executive section provision. So there may be others that they could use or could have used in the particular circumstance. Commissioner Newell.
Can you help me parse out the conduct deliberations portion of this clause?
That the governing body is typically it would be with their real estate broker or their attorney or city manager or whoever, is to be discussing with that person those aspects, deliberating, like here is what the,
here's the benefits of various places that we're looking at.
Well, or here is
the drawbacks,
the maximum price that we will pay and don't go above this, or here's our lowest bid that we will accept if we're selling.
Are there specific things that cannot be discussed in conducting deliberations?
The statute is silent on that, and the commission has not adopted any rule or, in my inquiry, issued any opinions relative to that.
I mean, I can understand certain prohibitions on active negotiation, but if you're having a discussion and you're deliberating and you're examining all of your various options, that seems within the spirit as well as the words here.
With the exception that, are there any negotiations taking place?
Well, to negotiate, you would need to have multiple parties, right? You'd need to have somebody with which you are negotiating. And if it's just the body itself discussing and deliberating its options with the person who is designated to act on behalf of that body, and I believe you said in here that the chair was that person, there was a commission. Was there an outside entity that was part of those negotiations at that time that would have been subject to those deliberations, or is the deliberation contained within the unit of the board itself?
The deliberation, as far as I understand, the deliberation was contained within the 3 members of the county commission.
I guess when I read this sentence, I see more of the emphasis on the conduct deliberations is the action that the board is taking in the executive session, not negotiation.
Correct. The board is not supposed to be negotiating. They are supposed to be deliberating with the person about the negotiation.
Okay. And is there anything in this that in this deliberation that is out of bounds?
what would be out of bounds is if there are no negotiations, if the person designated is not engaged in negotiations for a real property transaction, then what is the deliberation that would qualify under subsection E? If they are instead discussing long-term site planning or site needs, those are, according to the Attorney General's manual, not authorized for discussion in executive session under this provision.
Okay, so I think there might be a fine line between planning for negotiation, conducting your internal deliberations about what our strategy is for negotiation versus having those open discussions about what long-term needs are.
Yeah.
And it seems like perhaps the board has fallen into that gray area.
Absolutely.
Okay, thank you.
Thank you. Commissioners, any other questions for Investigator Myers?
I just have one clarification, if I could.
Who's this?
Commissioner Drago. Commissioner Drago, sorry.
Yeah, well, I'm going to give you an opportunity to respond right now. So why don't you go ahead, Mr. Drago, and then we'll have Mr. Sykes. Are you intending to say something as well, or just Mr. Drago?
It depends on what Mr. Drago says.
Okay.
No, I
Drago,
want
go
to
ahead.
repeat him, yeah.
Yeah, Mr. Drago, go ahead and we ask that you be precise and efficient with your time.
Yes, it's just Ms. Myers said that the negotiations were with the city of Boardman, and that is incorrect. It would be the city of Heppner. I just wanted clarification on that.
Thank you. Did you have anything else
Yes.
to say, or is that it?
I'll let Mr. Sykes, Chair Sykes, take it from here.
Go ahead, Mr. Sykes.
Yeah, I will repeat what he said, because the city of Boardman was nowhere in, the city of Boardman there was no site under consideration. We had a certain number of sites, and that's what we were dealing with. We weren't considering a site outside of Heppner.
I do apologize for that. I had a lot of Morrow County matters and occasionally get the cities blurred.
Thank you, Mr. Sykes. Okay, any questions for Mr. Sykes or Mr. Drago, commissioners? Okay, commissioners, we're now at that point to make a decision as to what we intend to do. Are there any commissioners that are prepared to make a motion?
Mr. Chair, this is Commissioner Fiscum. I will yield in a moment since I can't see anybody's hands or comments, or I can hear comments. If anybody wants to make a comment, my fellow commissioners, I'm happy to honor that before I make a motion. Thank you.
Commissioner Newell or Commissioner Thompson?
I mean, I think there's enough here to at least look at it, but my concern would, to Commissioner Newell's point too, where my concern would be if they were discussing general space needs, that's outside of what they should be doing. If they were discussing how specific sites might fit with their general space needs, then I feel like they're okay. So I guess I would just need to know more about the discussion. If there were specific sites, then I feel like that falls in executive session. But if they were just talking about, hey, we need a larger courthouse and it needs to be ABC, that might be different for me.
And if it helps, I mean, there were specific sites that they were discussing. They had narrowed Chair Sykes and this committee that they had formed, I forget what the acronym was, but the county and DOJ or whoever had been planning for a new courthouse. They need a new courthouse. And so they had been working on this for a number of months. And this committee, my understanding is that the committee had narrowed it down to 4 or 5 sites.
In that case, I feel like they're underneath the deliberations clause of that statute because they're talking about specific sites, and they make, and I can understand why you wouldn't want to do that in public when you're negotiating, when you could be negotiating with those property owners about that. So.
Are you prepared to make a motion? Commissioner Newell? Any other commissioner?
Mr. Chair, this is Commissioner Fiscom, and I am prepared in light of the discussion, which I have appreciated, to yield the motion-making opportunity to either Commissioners Thompson or Newell. If they would prefer for me to make the motion, I will do so.
I think they're deliberating. They're looking at each other right now, so.
Okay.
It's up to you. All right. I move the commission find that the complaint and information available during the preliminary review appears to be insufficient to constitute a substantial objective basis for believing that David Sykes has violated provisions in the
19266.
ORS 192-660 or warrant further review and that this complaint be dismissed.
Commissioners, we have a motion in front of us. Any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscom,
No. Nay.
Commissioner Burke. Thumbs up for aye. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
No.
Chair Lindsay.
Aye.
Motion passes 7-2.
Thank you. Agenda item 36?
35.
35. Do we have a motion on agenda item 35? Commissioner Thompson or Newell?
I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Jeff Wenholtz has violated provisions of ORS 192-660 or warrant further review and that this complaint be dismissed.
Any comments on the motion? Call for the vote, please.
Commissioner Newell.
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscom,
No.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
No.
Commissioner Hollister,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-2.
Commissioner Thompson, agenda item 36?
Mr. Chair, I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Roy Drago Jr. has violated provisions of ORS 192-660 or warrant further review and that this complaint be dismissed.
Seeing no comments, call for the vote.
Commissioner Mason,
Aye.
Commissioner Fiscom,
Nay.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
No.
Commissioner Hollister,
Aye.
Commissioner Newell.
Aye.
Chair Lindsay.
Aye.
Motion passes 7-2.
Thank you, Mr. Sykes, Mr. Drago. The complaints have been dismissed and we appreciate you being with us today.
Thank you.
Thank you.
Thank you very much. You guys have a great day.
Thank you. We'll now move on to agenda item 37 on its own. Completely unrelated, right?
Correct, yes.
I did more of that.
In for this one.
And 38's unrelated as well, right?
Just attorneys.
Oh, he's turned in one and
Susan didn't put him down as being a and I messaged him, but he didn't answer.
Hello, Mr. Lee, can you hear us?
Yes, I can. Can you hear me?
Yes, thank you for being here today. Will your client, Mr. Wenholtz, be with us today?
No, just me.
Okay, thank you for being with us. It's now time to hear his case. We'll start with Investigator Murrieta giving a report, and then you'll have an opportunity to respond as well.
Thank you.
Investigator Murrieta.
Great. Thank you, Chair, Commissioners. This is Investigator Hillary Marietta. Agenda item 37 is a preliminary review report for Jeff Wenholz, Morrow County Commissioner. The complaint in this case alleges that Jeff Wenholz may have been faced with a conflict of interest and used his official position to financially benefit a business with which he is associated, specifically Umatilla Electric Cooperative, or UEC. UEC is a member-owned not-for-profit electric cooperative that sells energy and support services in Umatilla, Union, and Morrow County. According to UEC's website, Jeff Wenholz is the vice president for the UEC Board of Directors and has been a board director since 2004. Additionally, according to UEC's revenue reports, Mr. Wenholz is listed as an officer of UEC. In the 2021 revenue report, he is listed as vice president with a listed compensation of $10,685. In 2020 revenue report, he is listed with a compensation of $10,678. Through his attorney, Mr. Wenholz makes arguments for why UEC should qualify as a not-for-profit corporation that is tax exempt under Section 501C of the Internal Revenue Code for purposes of these statutory provisions. Should this matter be moved to investigation, Commission staff will further investigate the validity of these arguments. However, even assuming that Mr. Wenholz's arguments are correct, it appears that UEC still qualifies as a business for purposes of ORS 244.020 sub 2, and that the exceptions set forth in 020 sub 1 and 13C do not apply because Mr. Wenholz serves as a paid officer as vice president. Since it appears UEC is a business with which Mr. Wenholz is associated, any action, recommendation, or decision that could or would financially impact UEC, he would have a conflict of interest. Regarding the Sunstone Solar Project support letter, it appears that Mr. Wenholz was faced with a potential conflict of interest as the solar project will be utilizing UEC's transmissions lines, which could financially benefit UEC. It appears that Mr. Wenholz did not publicly announce a conflict of interest. Regarding the Wheat Ridge facilities, it is unclear whether the agreement would financially impact Wheat Ridge facility and possibly affect UEC. Should this case be moved to investigation, Commission staff would look further into this agreement. Additionally, it appears Mr. Wenholz may have used his official position to sign a letter of support that would affect the business with which he's associated, specifically obtaining a financial gain for UEC. Mr. Wenholz did not refrain from discussion and signed the letter of support of the Sunstone Solar Project, an opportunity only available for his position. Further, it is unclear whether the agreement involving Wheat Ridge facility would financially affect UEC. Again, should this case be moved to investigation, Commission staff would look further into the agreement. The recommendation in your books is to move this case to investigation.
Thank you. Commissioners, any questions for Investigator Murrieta? Seeing none, Mr. Lee, hold on, okay.
Chair, I just wanted to share with my fellow commissioners, I was confused about what an electric cooperative was. And so I was wondering if it was somehow a government entity, and it's not. So just because that wasn't in the report, I thought I'd share that. So it has nothing to do with it. It's completely private. So there you go, in case you're wondering.
Thank you. Mr. Lee, now's your opportunity to respond, and we appreciate you being with us.
Well, thank you. Again, my name is Richard Lee. I represent Mr. Wenholz in this matter. And you've already given me the opportunity. I was going to request the opportunity to be heard pretty briefly on matters addressing one sort of, well, I hesitate to call it unusual, but sort of a twist in this particular case. And the twist is that there was a response submitted by Mr. Wenholz to the complaint, which through no fault of anybody, was not considered during the course of the preliminary review. It seemed to have gotten lost in the cyber electron world somewhere. And so what I want to do is just touch very briefly on those things. And in a general matter, I will tell you what I'd like to request, and I acknowledge there's problems with it. But since there was a response submitted which did not enter into the calculus by the investigator, what I really would request would be a redo to consider the material that was submitted. I recognize there are time limits. There's a 90-day deadline to complete the preliminary review, and then things get put to this commission for it to take an action. And if there's not an action taken, I think it's deemed denied or no further proceedings. On behalf of Mr. Winholtz, we would certainly waive any timing requirement and certainly nobody's here to play a gotcha and say if it wasn't resolved today, that's deemed denied. Again, that's the request. Now, turning to the specific matters, what I want to touch on are the 3 actions that are the subject of the complaint. The complaint was fairly vague. And in the materials submitted, we tried to add some precision to the action taken. The first one is the February 8th, 2023 meeting. The action taken was an amendment of an existing contract between Morrow County and an entity I'll just refer to as Wheat Ridge East. That action was to change the capacity in Morrow County. It did not change the overall capacity of the project. And that project, Wheat Ridge, does have a contract with UEC, but that contract was for the full capacity. This action only moved a certain capacity from an adjoining county into Morrow County. So since it didn't change the overall capacity, there was no impact on UEC or potential impact on UEC. It was a transfer from one county to another. The second action taken was this is at the June 21st, 2023 meeting. There was a 1-page letter of, I'll call it support for a project called the Sunstone Solar Project. For the Sunstone Solar Project, Morrow County had entered into a contract with Sunstone long before Mr. Winholtz became a commissioner. This action and the letter outlines the existing contract and its potential benefits to Morrow County. And then in the concluding paragraph of that letter, it says, while the board is supportive of the financial opportunities with this project, we continue to recognize and support the official regulatory business of the Siting Council. And this letter was to the Siting Council. And that is it. And again, what we submitted in the materials provided and would submit now is a letter that simply says we support the existing contract we already entered into and also support your job. Again, there is no potential impact on UEC, certainly no direct impact on UEC. The last action taken is the September 20th, 2023 board meeting. And that action was approving a letter to be sent to the siting officer or the officer addressing the Sunstone project on behalf of the Siting Council. It provides comments on the preliminary application for a site certificate by Sunstone Solar as requested by the Siting Council. The staff prepared the letter, the board approved it. The opening paragraph, again, states that Morrow County endorses the advancement of solar energy in this project, again, for a contract that had been entered into long before this. The actions then are specific comments on specific components of Sunstone Solar's project. There's no, sorry about that, I had my phone on so I could get text messages from you folks. I've turned it off now. This specific action, the specific comments, there's no basis to conclude that any of those specific comments, which are things like you need to consider roads and there's this land use thing and stuff like that, has any potential impact on UEC. Not even 100% sure what the impact really is on Sunstone Solar, as a matter of fact. Anyway, those are the issues that were not presented. Well, were presented, but again, got lost. And I'm not blaming anyone here. It just seemed to have one of these things that happened that I would wish the commission to consider. I'm happy to touch briefly on this non-profit corporation and board member officer status if anyone would like me to. That was addressed. And again, my real purpose in being here today was to talk about these things that, again, got lost through no fault of anyone.
Thank you, Mr. Lee. Appreciate your time and comments. I do note that we, the commissioners, received the letter on Tuesday. And I guess my question to Investigator Marietta is, does that letter, when you eventually received it, does that change your analysis with respect to today?
Yeah. Thank you, Chair. Yes, so I did review the response. I admittedly didn't really have time. I mean, some of these minutes I already had. I didn't have time to look at every single thing in the contracts, but I would say that it does seem like some of this information isn't like confirmed yet. Even Mr. Wendholz admittedly, it appears isn't sure about everything. And so I would say that it doesn't change anything just because I do need additional information to confirm some of this stuff. I guess it seems to me the basics is projects utilizing UEC's line to me seems to they would get a financial benefit from that. That seems the simple question to me. And I would want to look into that more. You know, Mr. Lee is saying that's not the case. I think I need some more information to look further into that.
Thank you. Thank you. With respect to Mr. Lee's request, my understanding, we really don't have any wiggle room at all statutorily. So we understand that situation. And I don't think there was a malintent on anybody's side. And but it is what it is. So comments or questions for Mr. Lee from any of the commissioners? See no comments. Commissioners, are we prepared? Is any commissioner prepared to make a motion?
Mr. Chair, this is Commissioner Fiscum. I'm prepared to make a motion. Again, I'm blind, so if there's anybody else wants to comment first, I'll yield the floor.
I don't see any others making a motion, so go ahead.
Thank you, Chair. I hereby move that the commission find there is a substantial objective basis for believing that, Jeff Wendholz may have violated ORS 244.04 ORS 244.040 sub 1 and ORS 244.120 sub 2. Thank you.
Thank you. Commissioners, any comments on the motion that is before us? I have a couple comments, and that is I appreciate Investigator Marietta's comments on what she intends to discover. I expect that I expect there will not be any material outcomes there, but I do support the motion because I think we need to iron out some of the facts. I also appreciate Mr. Lee's transparency and comments and suspect that we're going to arrive at a mutual resolution. And so for that reason, I'll be supporting the motion. Yeah, any other comments on the motion? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you, Mr. Lee. Again, this has simply been a decision, no decision that there has been any violation. It's simply a decision to move beyond the preliminary review portion into investigation. Investigator Marietta will be working with you to iron out some of those facts.
Understand. Thank you. Again, thank you for letting me appear.
Thank you. You have a good day.
All right.
All right, it's 10:35. Anybody need a break, a 5-minute break? We'll take a 5-minute break. We will meet back here. Is 5 minutes okay? We'll meet back here at 10:40. Okay? See you in 5-6 minutes.
Thank you.
Like, sit here tapping away, and we're going.
You got a meeting.
Yeah, okay. I didn't know if there was something different.
It's like first year. Alicia.
Just to let you know.
I think it's did you forget, right?
Right.
Let Susan get settled here. All right, folks, we're back in executive session, continuing. And it looks like we have everybody online, so I think we're good. So, all right, we're now moving on to agenda item 38. Mr. Doherty. It looks like
admitted right now.
he's being admitted.
And pick me on.
Hello, Mr. Doherty, are you online?
I am. Can you hear me?
We can hear you. Thank you for being with
Okay.
us today. Now's the opportunity that your case will be heard before the commission. And how it will happen procedurally is Investigator Myers will present to the commission her findings for preliminary review. And then you will have an opportunity to respond as well. And so we'll go to that point, okay? Investigator Myers.
Thank you, Chair Lindsay. Commissioners, for the record, this is Susan Myers. Item 38 is a preliminary review report for Jim Doherty, a former member of the Morrow County Commission. In late 2020, Jim Doherty was serving as a county commissioner, and in that role participated in meetings where the Board of Commissioners and county staff were discussing CARES grant funding and applications. And this was one of the sort of COVID relief grants that the state and federal government made available. Because businesses that he and his son owned were applicants for the CARES grant funding, Mr. Doherty was met with actual conflicts of interest, as any decisions on the county's grant application process and grant funding would have a certain financial impact on their businesses. It appears Mr. Doherty participated in 4 meetings in December 2020 when the Board of County Commissioners discussed the grant application process, deciding on funding for various categories of applicants. He made no conflicts of interest disclosures at the first 2 meetings. In the 3rd meeting, he participated in the discussion, but then abstained from the vote, saying he was sidelining himself. And in the final meeting, he again abstained, but in this meeting made a more complete conflict of interest announcement. It appears in this case, thus, that Mr. Doherty had actual conflicts of interest and failed to satisfy the disclosure obligations in ORS 244-120. Further investigation is also needed to determine whether Mr. Doherty engaged in a prohibited use of office. It appears he may have been involved in setting up what the criteria would be for the applicants and prioritizing that funding. Because he and his son were applicants, any suggestions or recommendations or proposals that he made to direct more funding toward one category of applicants versus another would give rise to a violation to a prohibited use of office. The recommendations in your meeting books is to move this matter to investigation.
Thank you. Investigator Myers, the question I had was, in those deliberations, did they talk about specific companies, or was it just general?
They appeared to be talking about, initially there were discussions about what will our application look like. Then they were talking about categories, like if we have this amount of funding, $600,000 to distribute, or 6 million, whatever the amount was, should we give X amount to tourism related businesses, a larger amount to cattle related or agricultural businesses, etc. His son's company is an outfitters. He and his wife own a cattle company. So they were deliberating what amount of money to give to each category of business, and his businesses were included in some of those categories.
Thank you. Commissioners, any other questions for Investigator Myers? Seeing none, Mr. Doherty, as this is your opportunity to respond, and we do ask, we have a long agenda today, so we do ask that you be efficient with your time.
Yeah, no, I appreciate that, commissioners, and I will be brief. It is kind of unique that I'm a cattle rancher, but I also have a production sale, right? It's a one-off each year when I sell my bulls, and I think it was just days before my sale that, the governor put the freeze on things, and the most onerous thing, the best thing I could have done financially, right, would have been move forward with my sale the orders, but I was asking other businesses to adhere to her freeze, and it certainly, I'm still struggling, from the financial loss that happened. But as we move forward and we voted on the CARES grants, all three commissioners did, I had no, thoughts or knowledge, or even as we worked on what categories that my business may, qualify or make application. In fact, I think it's important for the commission and the record to note that it was probably the most onerous disagreement that I've had with my spouse or business partner. Once the criteria was set up, and she said, look, our business qualifies relative to having to shut down everything, and I said, yes, but the political fallout and the optics of it, right? And she argued rightly so that as an elected official, it shouldn't preclude her from trying to get some minimal recovery. And so the applications were made. She did make application on the business's behalf, and my son made application. But at no time did I ultimately hold any authority over, which categories got what funds and these things, or any votes, right? I mean, ultimately, all of that was decided by the other two commissioners. And even as Kate Knopp, the finance director, or Mr. Zodi worked through these applications, once mine come in, or those came in, I stepped back from that committee. But that committee never, ever, they just looked at the base criteria, right? Were they registered in the state, in the county, and even the ones that didn't check all the boxes, weren't cast aside. They all came, ultimately to the board, and the other two commissioners made, all of the decisions and, and all of the votes. I don't disagree with Ms. Myers, but I certainly think it's a mea culpa that you can't just not vote, right? You have to declare why you're not voting, and that certainly was a misstep. But at no time did in fact, I would argue that I never foresaw my business ever putting in application. And once the application, came in, I tried to, step back out of the committee, and as they reviewed those and or, made decisions relative to all of the applications that came in, I sidelined myself. And of course, you can't just sideline yourself, right? You got to declare why you're sidelining yourself. But so that's kind of the long and the short of it. I don't think that I ever, held any sway one way or another. Ultimately, all the decisions, all the ranking or criteria or payout or, what businesses got what, was solely decided by the other two commissioners.
Thank you. Appreciate your transparency and intent to do what's right. Commissioners, are there any questions for Mr. Doherty that you might have? All right, commissioners, anybody prepared to make a motion as to what we do next?
Mr. Chair, this is Commissioner Fiscum. I'm prepared to make a motion. The quick preamble is I want to associate myself with your remark. I appreciate the clarity, honesty, transparency of the respondent's comments to us today as he tried to do the right thing. That said, I hereby move that the commission find there is a substantial objective basis for believing that James Doherty may have violated ORS 244.040 sub 1 and ORS 244.120 sub 2, and that the commission should investigate accordingly. Thank you.
Thank you. Commissioners, we have a motion before us. I have some comments on that motion as well. I definitely have some sympathy here for Mr. Doherty. Not only was COVID uncharted waters, but more importantly, clarity about the grants became clear. I can see kind of him clarifying, oh wait, this might be. And so as it progressed, so did his voting and disclosure progressed as well. And I obviously see an intent to do what is right here. So I'll personally be supporting the motion, but I hope that it's a more on a letter of instruction and help him be compliant and for future things. And so those are my comments. Any other comments on the motion from any of the commissioners? Seeing none, we'll call for the vote.
Commissioner Fiscum,
Aye.
Commissioner Burt. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you, Mr. Doherty. What we've decided is not a violation. We've decided simply to move beyond the preliminary review to investigate a little bit further and to work with you to iron some things out and hopefully get to a mutual agreement on resolving this fully.
Yeah, no, I appreciate that. And thanks for the opportunity.
Thank you. You have a good day.
You too. Bye-bye.
All right, we are now on to agenda item 39, Mr. Johnson, who will be attending via Teams.
Is it?
Mr. Johnston, can you hear me?
Yes.
Welcome. My name is Sean Lindsay. I'm chair of the Oregon Government Ethics Commission. Now's the time to hear your case that's been brought before us. Procedurally, what's going to happen is Investigator Walker is going to provide a report to the commission, and then you will have an opportunity to respond to that report. And then after that, we'll make a decision as to what the next procedural steps will be. With that said, Investigator Walker, go ahead, please.
Thank you, Chair Lindsay and Commissioners. For the record, this is Monica Walker, investigator for the Commission. Agenda item number 39 in your meeting books is a preliminary review report for an ethics case involving Paul Johnston, Jewel Foreman for the Clatsop County Public Works Department. It should be noted that additional information was received this week from the county's attorney, Anthony Pope, and forwarded to the commissioners. As the deadline for the preliminary review phase had passed, the information was unable to be reviewed and included in the case summary I will be providing. The complaint filed with the commission alleges that Mr. Johnson may have used or attempted to use his official position for personal financial gain and failed to declare a conflict of interest by using a Clatsop County issued vehicle, specifically a truck, to commute to and from work, as well as haul his personal trailer, and that he did so without first declaring a conflict of interest. From the information submitted, the County Public Works Department received 2 complaints in August of 2023. The complaints asserted that Mr. Johnson used his work vehicle to tow his personal trailer to a rental space in Anderson Park in Vernonia, which is in Columbia County, Oregon, violating a Clatsop County policy which addressed the use of county equipment for personal benefit. A review of the county's investigation into the matter indicated the county only investigated Mr. Johnson's pulling of the trailer and found that Mr. Johnson was not in violation of any county policies, thus closing the complaints filed. Staff's review of the county personnel policies referenced in the county's investigation report revealed that the county policy did not address an allowance for Mr. Johnson to commute to and from work. Rather, it stated that county automobiles are to be used for county business only. County automobiles are not to be used for personal business. Per staff's conversation with the park host, Mr. Johnson rented a space as his temporary residence in the park beginning on July 10th of 2023 for a little over a month, and always pulled and parked his trailer with his personal truck, only using the county vehicle to commute to and from work. Additionally, no documentation was ever received providing confirmation that Mr. Johnson was ever actually seen pulling his trailer with the county vehicle, and photos received only showed the county vehicle parked in front of the trailer, which was stored at the park site on a wooden block. The information would support that Mr. Johnson did not use the county vehicle issued to him to pull his personal trailer. As the county did not appear to investigate whether Mr. Johnson was using the county vehicle to commute to and from work, and the county's personnel policies did not appear to authorize the use of a county vehicle for personal commuting from home to work or otherwise, it appears Mr. Johnson may not have been authorized to utilize the county vehicle to commute to and from work as part of his official compensation package, thus appearing to violate the use of office and conflict of interest provisions. Should the commission move this matter to investigation, staff would review the additional documentation received from Mr. Pope, County Counsel, this last week to determine if the county had any additional policies which would allow for Mr. Johnson's commute to and from work or otherwise. Based on the information received during this preliminary review, it appears there is substantial objective basis in this case to believe that a violation of the prohibited use of office and conflict of interest statutes may have occurred. Therefore, the report in your meeting books recommends moving this case to investigation.
I did review the letter from the whoever sent it.
County attorney.
Attorney, right. And it seems that they said, okay, well, we've cleaned this up. There was never the intent. Does that change anything? Or did I hear you correctly that it was not considered in your report?
It was not considered because there's a 60-day deadline for the preliminary review report that was received this last week. It's my understanding that we can't consider anything once that's completed. If it moves to investigation, then we certainly could consider it.
Right. Assuming we did go to investigation, it seems to me that might clean things up. Right. Okay. Thank you. Any questions for Investigator Walker?
Mr. Chair, just a procedural question.
Commissioner Thompson first, and then we'll go to you, Vice Chair.
While investigator could not consider the information, we can, correct?
Yes.
Okay, thank you.
Vice Chair Fiscum.
I'm ready to make a motion unless colleagues want to make a motion, but I think Mr. Johnston is here and may want to speak first here.
Yes, I didn't know if you had a question for Investigator Walker.
I don't have a question right now. Thank you.
Okay. Mr. Johnston, it's now your opportunity to respond, and we do ask that you be precise with your time because we have a heavy agenda today.
Yeah, no problem. I just like to say that Mr. Pope is present at this time with me.
Thank you. I appreciate it. Did you have any other response?
This is Anthony Pope, County Counsel. I just kind of I don't want to duplicate my testimony to conserve time, but just from the county's perspective, Mr. Johnson didn't do anything wrong. It's been a longstanding practice for the foreman to be able to use the vehicles for commuting. If there's any deficiencies here, it's really kind of on the county not having our policies up to date to the practices that we were following. So when we received the complaints, we did investigate to see if there was, a commuting happening because we'd given permission and we thought everything was okay with that.
Okay, thank you. Commissioners, any questions for Mr. Pope or Mr. Johnston? Seeing none, Vice Chair Fiscum, I understand you're prepared to make a motion?
I am, Mr. Chair. The preamble is that I think we're dealing here with if you will, a technical violation that can get cleaned up very quickly. That said, I will hereby move that the commission find there is a substantial objective basis for believing that Paul Johnston may have violated ORS 244.040 sub 1 and ORS 244.120 sub 1 sub C, and that the commission should investigate accordingly.
Thank you. Commissioners, any comments on the motion in front of us? Commissioner Thompson.
Yeah, Mr. Chair, I appreciate the constraints the investigator was working under, but I think that the information we received this week changes things drastically. My opinion, Mr. Johnston was just following what he was told to do by his supervisors, and there was, I mean, he didn't pull the trailer with his company truck, and my understanding is that, you know, these supervisors are on call 24 hours a day and need these trucks to do their job. So I am not in favor of moving this forward, and I will be voting against the motion.
Do you want to make your own motion?
No. Let's vote no.
All right. Any other comments on the motion? Go ahead, Vice.
Mr. Chair, this is Commissioner Fiscom again. In light of the comments, I'm happy to withdraw my motion and yield to my colleague for another motion, a different motion. So if that's permissible, I would be happy to do that to attempt to move toward a resolution here. So I withdraw my motion.
Thank you. Motion was withdrawn. We have no motion on the table. Commissioner Thompson, are you prepared to make a motion?
Why not? Mr. Chair, I move the commission find that the complaint and information available during the preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Paul Johnston has violated provisions in ORS 244-040 sub 1 and ORS 244-120 sub 1 section C, and or warrant further review and that this complaint be dismissed.
Thank you. Commissioners, we have a motion in front of us. Any comments on the motion made by Commissioner Thompson? Seeing none, we'll call, hold on, we might have, oh, no comments. Okay, seeing none, we'll call for the vote.
Commissioner Burke? Thumbs up. Commissioner Thompson?
Aye.
Commissioner McCauley?
Aye.
Commissioner Payne?
Aye.
Commissioner Hollister?
Aye.
Commissioner Newell?
Aye.
Commissioner Mason?
Aye.
Commissioner Fiscom?
Aye.
Chair Lindsay?
Aye.
Motion passes 9-0.
Thank you. Mr. Johnston, Mr. Pope, this means that the case has been dismissed. Thank you for being with us today, and we appreciate your efforts to comply and to continue to comply with ethics rules of Oregon. Thank you.
Thank you.
Thank you, Commissioner.
Yeah. All right, we are now on to agenda items 40, 41, 42, which seem to be related, but we're going to handle them independently.
No, we can handle them together. None of them are appearing.
None of them are appearing, so we can address 40 through 42, correct? And that will be addressed by Investigator Myers.
Thank you, Chair Lindsay, Commissioners. For the record, this is Susan Myers. Items 40 to 42 are preliminary review reports for 3 of the members of the Board of Directors for the Prospect Rural Fire Protection District. The complainant in this case is actually a member of the District Board of Directors. He previously did file a complaint which was dismissed by the Commission at its November 17th meeting because he had not at that time met the filing prerequisites for a public meetings law complaint. He did satisfy those prerequisites and then resubmitted his complaint. These cases involve both executive session and public meetings law allegations of violations. On September 23rd, the district was holding an executive session to consider changes and an extension, I believe, of the fire chief's contract. So the first issue in the case is that the board appears to have violated the notice provisions in the public meetings law. 192.640 requires that a governing body give public notice reasonably calculated to provide actual notice to interested persons of the time and place for meetings. In this case, the board issued multiple meeting notices, each of which identified a different location for the meeting. One said it would be at the community center, another at the library, and a third at station number 1. by failing to clearly identify the location of the meeting in its notices, the board failed to reasonably give actual notice to interested people of the location for the meeting. The second issue in this case is that the board appears to have violated ORS 192660 sub 2. Specifically, they convened the executive session under subsection 2A. That provision relates to initial hiring of employees, staff members, agents, etc. It does not appear that the discussion of the fire chief's contract or an extension, the contract terms, would qualify under subsection 2A. He was already an employee. It was not about his initial hiring. Additionally, subsection 2A has mandatory prerequisites. They are set forward in 192660 sub 7D. Advertise the vacancy, provide notice, adopt hiring standards, etc. So what happened in this case is that the complainant, the one board member, saw the notice that what he thought was going to be a work session was now an executive session under 2A, did some research, and he called us. He spoke to investigator Monica Walker on more than one occasion. And she advised that based on the information he was providing, it did not appear that they had met these statutory prerequisites, that this would be an unauthorized discussion. So when the fire board went to the meeting, they held a public session first before going into executive session. He appeared at that public session and spent about 10 minutes trying to explain to his fellow board members what Monica had said, what subsection 7D provided. They chose not to accept his advice. It appears they did not believe Monica existed and were not aware of our existence as commissions.
Yeah, that's right.
So anyway, he made the announcement in the public session that he would not be participating, that he had advised them not to attend, and he would be abstaining, and he left. One of the other board members was out with COVID at the time, so the 3 remaining board members chose to proceed with the executive session. Based on the information in this preliminary review, it appears that they may have violated 192660 sub 2 by having an unauthorized discussion in executive session. And as I said previously, also violated 192640 by not providing adequate notice.
Thank you, Investigator Myers. Any comments or questions for Susan and the commissioners? Seeing none, Vice Chair Fiscom, do you have a motion for us?
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Julie Moss may have violated ORS 192.640 and ORS 192.660, and that the commission should investigate accordingly.
Thank you. Commissioners, any comments on the current motion? Seeing none, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister, Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Burke. Thumbs up. Chair Lindsay,
Aye.
motion passes 9-0.
Moving on to agenda item 41, I understand it's the same report.
Correct.
Investigator Myers, and hearing that, Vice Chair Fiscom, do you have a motion?
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Wayne Scriven may have violated ORS 192.640 and ORS 192.660, and that the commission should investigate accordingly.
Thank you. Seeing no comments from the commissioners, we'll call for the vote.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Chair Lindsay,
Aye.
motion passes 9-0.
Thank you. Vice Chair Fiscum, agenda item 42.
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Joyce Deerking may have violated ORS 192.640 and ORS 192.660, and that the commission should investigate accordingly.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell, Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. Thumbs up, sorry. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay,
Aye.
motion passes 9-0.
All right, thank you. We're now on to agenda item 43 regarding Joyce, Mark Joyce. And that will be presented by Daniel, Investigator Pacheco. And I understand that Shauna Peterson, Mark's attorney, will be joining this.
Yes, she's been admitted. I don't have Mark. He's not in the waiting room. We have Sean.
Hello, Ms. Peterson. This is Sean Lindsay, Chair of the Commission. Are you, can you hear us?
I sure can. Thank you, Chair.
Thank you for
Mark
being.
should be joining.
That's what I was going to ask. Is Mark intending to join us then? We don't see him in the waiting room.
Is intending to join. Don't adjust your schedule. I did ping him to let him know, and I'll follow up on that. But proceed as you usually would, and I can cover it as needed.
Okay. We'll be following up with him. No need for you to do that, but we will proceed and we'll admit him when and if he shows. Procedurally, how this will happen is Mr. Pacheco, who's the investigator in this matter, will present his preliminary review to the commission, and we'll consider that, and then we will give you an opportunity to respond as well. So with that, Investigator Pacheco.
Thank you, Chair Lindsay and Commission. This is an investigator, Daniel Pacheco, for the record. Agenda item 43 in your meeting book is a preliminary review report for Mark Joyce, a board chairman of the Ventura Road Assessment District Number 4. The complainant in this case alleges that Mark Joyce used his official position to access district funds and equipment to improve roads in a region known as Grasshopper Flat, which in turn improved access to his cattle. Submitted with the complaint were maps of Grasshopper Flat, including labor logs and an invoice for work completed to fix roads in the region. Ventura Road Assessment District Number 4 is a special taxing district in Malheur County created for road maintenance. While Grasshopper Flat is within the district's jurisdiction, the roads in the area are under the care of the Bureau of Land Management, which allows the district to repair the roads in exchange for use of their bulldozer. Further review revealed that Mark Joyce owns a business in the Grasshopper Flat region under the name of Malheur Ranch LLC with his brother Daniel Joyce. Thus, in this case, it appears that Mark Joyce may have had the opportunity available to improve road access to his cattle and business, but for his official position. For ORS 244.040 sub 1, it is not allowable for a public official to create an opportunity for themselves, a relative, or business which they are associated with that could result in a financial benefit or detriment. In addition, for ORS 244.120 sub 2, when a public official is met with a conflict of interest, they must announce the nature of the conflict, and if it is an actual conflict of interest, they are prohibited from voting on the matter that gives rise to the conflict unless their vote is required to meet the minimum vote requirement. It is possible that a class exception could apply where Mr. Joyce would not be met with a conflict of interest or need to make a disclosure at the time he voted to make road repairs. In this case, the commission can determine that a class consists of all property owners within a certain proximity of Grasshopper Flat, all property owners who have cattle, or another class identified by the commission. Lastly, to determine if the class exception applies, the commission would need to identify if the use of district funds and equipment to make road improvements affected Mark Joyce, his brother, and their business to the same degree as all members of the class identified by the commission. If the commission were to find a class exception, it would only apply to the conflict of interest, not the prohibited use of office. Should this case move to investigation, commission staff would seek to identify the following: the times Mr. Joyce voted to improve roads in the Grasshopper Flat region, if he disclosed a conflict of interest, the circumstances under which the Bureau of Land Management approached the district to make road repairs, and if Mr. Joyce took any actions in his official capacity that could have resulted in a financial impact to his business. The recommendation in your books is to move this case to investigation.
Thank you.
Thank you.
Commissioners, any questions for Investigator Pacheco? Seeing none, we'll now turn to you, Ms. Peterson. Has Mr. Joyce joined us yet? Do we know? Okay. Ms. Peterson, go ahead. It's your opportunity to respond to the preliminary review. And we do have a heavy agenda today, so we do ask that you be efficient with your time. Thank you.
Thank you, Chair, and I appreciate that. My comments would be limited to 2 items. One, the nature, and I'm sure you see it especially with your smaller districts or commissions, the conflict of interest was well known to, if any, to all those voting. The record will reflect that it was known or disclosed. We could all, I suppose, improve on formal disclosure and confirming documentation in the minutes, but those tend to be lax. And if anything, this would be a reminder and nudge to do better. But any conflict what was well known. More significantly, it would fall under the class exception, which a mapping and the visual of the geography and the location of the road and the improvements made would clearly reflect.
Thank you. We appreciate your response and your client's intent to comply as best as he can. Commissioners, any questions for Ms. Peterson? Seeing none, we have a time to make a decision now. Do we have a commissioner prepared to make a motion?
Mr. Chair, this is Commissioner Fiscom, and I'm prepared to make a motion unless I have a colleague who wants to intercede, and I'll be happy to yield.
I don't see any, so go ahead.
Thank you, Mr. Chair. Thank you for your presentation before us to the respondent. That was helpful information. However, I hereby move that the commission find there is a substantial objective basis for believing that Mark Joyce may have violated ORS 244.120 sub 2 and ORS 244.040 sub 1, and that the commission should investigate accordingly.
Thank you. Any comments on the motion before us? Okay, seeing none, we'll call for the vote.
Commissioner Hollister,
Aye.
Commissioner Newell. Aye. Commissioner Mason,
Aye.
Commissioner Fisco,
Aye.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCully,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. Ms. Peterson, we have not determined that there was a violation. We've simply determined to proceed further beyond the preliminary review and investigate further and get some questions answered that Mr. Pacheco has. And we'll be in touch, and we thank you for your time with us.
Thank you all.
All right, we're now moving on to agenda item 44 regarding Chuck Schultz, who will be attending via Teams.
He is in right now.
Mr. Schultz, this is Sean Lindsay, Chair of the Commission. Can you hear us? Mr. Schultz, can you hear us? We cannot hear you. Maybe make sure your mute button is off. Not muted. All right, well, our let me tell you what's going to happen procedurally while Mr. Schultz, if you can hear us, hopefully you can. Procedurally, what's going to happen is Ms. Marietta is going to present her preliminary review, and then we will give you an opportunity to respond. Our staff will continue to work with you to make sure that we can hear you. And with that said, we'll go ahead and Investigator Marietta, go ahead, please.
Thank you, Chair. Commissioners, this is Investigator Hillary Marietta. Agenda item 44 in your books is a preliminary review report for Chuck Scholes, the Public Works Director for the City of Harrisburg. The complaint in this case alleges that Mr. Scholes used his official position to avoid a financial detriment by living in an RV on city property, specifically at a wastewater facility. In this case, it does not appear that the facility was open to the public for camping or lodging activities. Therefore, it appears the benefit of the camping lodging was only available to Mr. Scholes because of his status as a public official. Additionally, Harrisburg City Council meeting minutes indicate that the City Council was not initially aware that Mr. Scholes was residing at the facility, and it was never adopted into his official compensation package. The question is not whether Mr. Scholes saved the city money by providing security to the city facility, but instead whether Mr. Scholes used his official position to avoid a financial detriment of rent or lodging. While some city councilors argue that having Mr. Scholes present at the facility adds additional security and saves the city money, and that Mr. Scholes has possibly protected the facility, it does not appear there was a written policy in place as part of an official compensation package that allowed for Mr. Scholes to reside at the facility. And it appears that he has been residing at the facility for several years. When Mr. Scholes began residing at the city facility, he received a private financial benefit, and therefore he was met with a conflict of interest that needed to be disclosed to his appointing authority. There is presently no information to indicate that Mr. Scholes declared a conflict of interest. The recommendation in your books is to move this case to investigation.
Thank you. Any questions for Investigator Marietta? Commissioners? Seeing none, hopefully Mr. Scholes we can hear you. Can you hear us, Mr. Scholes?
He's muted, it looks like.
Looks like you're muted. Maybe you can try to take that off. Mr. Scholes, can you try to remove the mute on your computer? Or can staff remove the mute?
We cannot. We have texted him to see if he can hear us. We are waiting back for a response.
Okay. Well, I don't know what we do procedurally if he doesn't show. I assume we have the permission just to proceed forward, right?
Yes.
Yeah. All right. Well, seeing that Mr. Scholes, we cannot hear him, we'll proceed forward. Any Vice Chair Fiscum, do you have a motion to make?
I do have a motion, Mr. Chair. I will just say as a preamble, I have some mixed emotions about this motion that I will make based on only the reading of our investigator's report. I wish Mr. Scholes was here to make some comments. It sounds like we are at risk. This is a perception from me, perhaps not a fact, of via this process inserting ourselves into some kind of a local dispute, which has been almost handled locally, and now it comes to us. So I have some misgivings about that. But, Mr. Chair, that said, I hereby move that the commission find there is a substantial objective basis for believing that Chuck Scholes may have violated ORS 244.120 sub 1 and ORS 244.040, and that the commission should investigate accordingly.
Thank you. Commissioners, I understand that Mr. Scholes can hear us, but we cannot hear him. Mr. Scholes, I'll just repeat what's happened thus far, understanding that you can hear us. Investigator Marietta provided her report. Commissioners had the opportunity to ask questions of her. Vice Chair Fiscum has made a motion to proceed beyond the preliminary review and to conduct a further investigation to clarify some facts. So that's where we're at procedurally, and the opportunity is now for the commissioners to make comment on the motion before us. And Commissioner Hollister has her hand raised. Go ahead, Commissioner Hollister.
Thank you, Chair. I have a question for staff. I'm just trying to get my head wrapped around the difference between compensation and job duties here. I mean, if I tell an employee it's your job to be present at this space, overnight, versus, you have the benefit of being at this space overnight. I mean, it seems like the analysis under the statute might be different, and I'm just trying to grasp sort of where that line is. I mean, I know in Oregon, at least, we have an obligation to pay someone a certain amount, if they are required to be present and on call in certain circumstances. So I just feel like this case might cross some lines, and I don't know if you have any guidance on that.
Yeah, thank you, Commissioner Hollister. I would say that there's no information to indicate that this was part of his job duties at all as Public Works Director. Like, I haven't seen anything that in the past as Public Works Director, that's part of their job to guard this wastewater facility. It seemed like this was a benefit to him that he had because of his Public Works Director position. And I mean, if, maybe that is the case, that it is part of their duties, which it doesn't seem like it is because the city council wasn't aware of it. I would say that that's something we can look into an investigation. But to me, it doesn't appear that this was a part of the job like other public officials we've seen in the past, being able to have, the city car all the time because they're on call. This seems to me that he was using his position to avoid a financial detriment and have access to the wastewater facility. Does that make sense? I hope that makes sense. Yeah.
Yeah, I think that's helpful. I think I just would want to clarify that issue as we move forward.
Absolutely, for sure. Thanks.
Thank you. Commissioners, any other comments on the motion before us? Seeing none, we'll proceed with the vote.
Commissioner Newell? Aye. Commissioner Mason?
Aye.
Commissioner Fiscum?
Aye.
Commissioner Burke? Thumbs up. Commissioner Thompson?
Aye.
Commissioner McCauley?
Aye.
Commissioner Payne?
Aye.
Commissioner Hollister?
Aye.
Chair Lindsay?
Aye.
Motion passes 9-0.
Thank you, Mr. Scholes. Hopefully you can still hear us. What's happened is we have voted. We have not found any violation by you. We've simply voted to proceed further with additional investigation and fact finding. And our staff will be in touch with you and to resolve these outstanding factual questions. Thank you for being with us today, and we'll move on to agenda item 45. Agenda item 45 is regarding Representative Greg Smith. He will not be attending. And Investigator Myers will be presenting. And just out of the gate, I served with Greg Smith in the legislature a long time ago. I don't think I have any conflict. I don't have any statutory conflict at all, but I just wanted to at least disclose that to you. We are in the same caucus, but have always had a very arm's length relationship, but I don't have any conflict of interest. With that
Mr. Chair,
said,
this is Commissioner Fiscum, quickly, and I thank you for your comment. I'd make a similar but not identical comment. I know Mr. Smith fairly well from a number of years at the Capitol when I was functioning as a lobbyist. I'm now retired. I have no relationship with him, thus I have no need to declare a conflict of interest, but for the record, I wanted to make that point clear. Thank you very much.
May I also jump on this bandwagon and declare that I have no conflict, even though I worked with Representative Greg Smith for a number of years in my capacity as a nonpartisan staff member in the Oregon legislature.
thank you. Investigator Myers.
Thank you, Chair Lindsay, Commissioners. This is Investigator Susan Myers for the record. The complaint in this case alleged that Representative Smith failed to report all of the sources of income on his statements of economic interest because he did not report the income that he and his wife earned from the Legislative Assembly, and he did not report his adult children's income. ORS 244.060 sub 3 and the SEI question number 2 requires filers to report the name, address, and brief description of each source of income received in the preceding calendar year by the public official or a household member if that source of income contributed 10% or more of the total household income. Representative Smith's SEIs reported two sources of income, his company and the Columbia Development Authority. During the preliminary review, he provided information that one, his adult children are not household members, and so there would be no obligation to report their income. And two, information showing that his annual household income exceeds $1 million, and the amounts that he and his wife earned from the Legislative Assembly did not meet the 10% threshold. Therefore, there was no requirement to list the Legislative Assembly as a source of income. The recommendation in your meeting books is that this matter be dismissed.
Thank you, Commissioners. Any questions for Investigator Myers? Seeing none, Vice Chair Fiscum.
Mr. Chair, I move that the commission finds the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Greg Smith has violated government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. Seeing no comments on the motion, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCully,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell, Chair Lindsay,
Aye.
motion passes 9-0.
Thank you. We'll now move on to agenda item 46, Sherry Kinsey.
Okay, Lindsay, we can do 40. Oh, yes, Sherry's appearing. I forgot.
She's on.
Hi, Ms. Kinsey. This is Sean Lindsay. Can you hear me?
Yes, I can.
Thank you for being here today. I serve as chair of the Oregon Board of Government Ethics Commission. And we're here. This is the opportunity to hear your case now before us.
Okay.
Investigator Myers will report to us first, and then you will have an opportunity after that to respond. And so we'll proceed to that point. Okay. Thank you. Investigator Myers.
Thank you, Chair Lindsay. Commissioners, for the record, this is Susan Myers. Item number 46 in your meeting books is a preliminary review report for Sherry Kinsey, the now former mayor of the City of Lakeside City Council. The case presents a public meetings law complaint concerning the City Council's October 2nd work session. The complaint alleged that the City Council violated public meetings law by making a decision or taking action in that work session. The term work session, as the report details, the term work session is not defined in the public meetings law itself. There is an Attorney General opinion from 1980 that clarified a work session is a meeting subject to the public meetings law at which no decisions are made, motions acted on, arguments made by the board members. Rather, its purpose is for the governing body members to hear staff reports or recommendations and gather factual information needed for future deliberations. In this case, it appears the City Council held the work session on October 2nd to hear presentations from a DEQ representative, the city attorney, and the city manager concerning issues with the city's code enforcement efforts, particularly relating to homeless encampments. In the work session, the city manager indicated that she and the city attorney would continue to research possible ordinances and solutions and bring the matter back to the City Council at a future meeting. It does not appear that City Council itself made any decisions or took any votes during the work session. Therefore, The recommendation in your meeting books is to dismiss the complaint.
Thank you. Any questions for Investigator Myers from the commission? Seeing none, Ms. Kinsey, this is your opportunity to respond, and we do have a heavy agenda today, so we ask that you be concise with your time, and especially understanding that the recommendation is to dismiss it. So go ahead, Ms. Kinsey.
I really don't have anything to add. I stated everything in the email that I responded. We did not make any decisions whatsoever. The complaint came from a Facebook post that somebody had posted. That's all I have.
Okay. Well, thank you. We appreciate you being here today and taking this seriously and taking time out of your schedule to be here. Thank you. Commissioners, any questions for Ms. Kinsey? Seeing none, Vice Chair, do you have a motion?
Mr. Chair, I hereby move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Sherry Kinsey has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. Commissioners, any questions or comments on the motion before us? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke. I'm sorry, Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell. Aye. Chair Lindsay,
Aye.
motion passes 9-0.
Thank you. We'll now move on to agenda items 47 through 51. Or through,
Do we need to let Kinsey go?
oh, I'm sorry. Ms. Kinsey, I apologize. Thank
Yes.
you. This has
That's
been
all right.
dismissed. This has been dismissed. And thank you for being here and have a great weekend.
Thank you, you too.
Thank you. Bye.
Bye-bye.
Sorry about that. All right, so agenda items 47 through 51, correct? All right, and they will not be attending, all with Investigator Myers. And is it the same report?
It will be the same report.
Okay, do you have to repeat it or so we can move forward? Okay. Commissioners, it's the same report that Susan gave on item 46. Same report for agenda items 47 through 51, which of course is recommending that we dismiss all of them. Vice Chair Fiscum, agenda item 47, please.
Yes, sir, Mr. Chair, I hereby move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Karen Hearn has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Fiscum,
Aye.
Commissioner Burke, Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell. Aye. Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Vice Chair Fiscum, agenda item 48.
Mr. Chair, I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Jackie Smith has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. Seeing no comments on the motion, we'll call for the vote.
Commissioner Burke. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne, Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell. Aye. Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Chair Hollister, I'm sorry, Chair Lindsay.
Aye.
Motion passed 9-0.
Thank you.
It's gonna,
Agenda item 49.
Mr. Chair, I hereby move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Nikki Wood has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Mr. Hollister,
Aye.
Commissioner Newell, Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke, thumbs up. Chair Lindsay,
Aye.
motion passes 9-0.
That was 49, right?
Yes.
Okay. Agenda item 50.
Mr. Chair, I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Thomas Miller has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. Please call for the vote.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
I'm so sorry, Commissioner Hollister. Commissioner Hollister. Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke, thumbs up. Commissioner Thompson,
Aye.
Chair Lindsay,
Aye.
motion passes 9-0.
Thank you. And agenda item 51.
Mr. Chair, I hereby move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Alan Pointer has violated provisions in the public meetings law or warrant further review, and that this complaint be dismissed.
Thank you. And we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Burke, thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay,
Aye.
motion passes 9-0.
Thank you. We'll now move on to agenda item 52 regarding Alicia Chapman, who will not be appearing, and Investigator McIntyre will be presenting. Go ahead.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item number 52 in your meeting book is a preliminary review report for Alicia Chapman, a commissioner for the Oregon Transportation Commission. The complainant in this case alleges that Ms. Chapman may have violated ORS Chapter 244 based on what she stated at the Historic Albina Advisory Board, also known as HAB, meeting on September 26, 2023. Submitted with the complaint was a link to a YouTube video of the meeting. I reviewed the recording of the HAB meeting where Ms. Chapman made a fairly clear disclosure of a potential conflict of interest where she stated that her business hoped to be a builder or supplier on the I-5 bridge project. It appears that Ms. Chapman may, at most, have had a potential conflict of interest as she hopes to be a builder for Oregon Department of Transportation projects and does not have an actual conflict of interest as these projects appear to be in flux and may or may not move forward. Further, nothing that was discussed with certainty would impact Ms. Chapman's business, and there was no decision-making at the HAB meeting on September 27th related to projects approved by ODOT. Therefore, it does not appear there is an actual conflict of interest with anything Ms. Chapman discussed at the HAB meeting, and she disclosed that potential conflict of interest at the start of the meeting. Ms. Chapman was also adamant that she discloses any conflict at every OTC and advisory board meeting that she speaks at. It also does not appear that Ms. Chapman has used her position for the financial gain or avoidance of a financial detriment for herself, a relative or a household member, or any business with which she, her relatives, or household members are associated, if the financial gain or avoidance of financial detriment would not otherwise be available but for holding of the official position or office. There was no information presented during the preliminary review to indicate that Ms. Chapman had made decisions or used her position at the Oregon Transportation Commission to benefit her private business. While her business did work on prior Oregon Department of Transportation projects, that predated her appointment to the OTC. Since being appointed as an OTC commissioner, Ms. Chapman's business has not bid on or contracted to work on any ODOT projects. Therefore, based on the information available during the preliminary review, there does not appear to be a substantial basis in this case to believe that Alicia Chapman violated ORS 244.040 subsection 1 or ORS 244.120 subsection 2. Therefore, the Oregon Government Ethics Commission should move to dismiss the case against Alicia Chapman.
Thank you, Investigator McIntyre. Commissioners, any questions for Investigator McIntyre? Seeing none, Vice Chair Fiscom.
Mr. Chair, just a quick preamble again before I make a motion. One, I want to express my appreciation for our two new investigators, Mr. McIntyre and Mr. Pacheco. This may be their inaugural foray before us. Each did a good job. I appreciate the clarity of their presentations. And Mr. Chair, that said, I move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Alicia Chapman violated provisions in government ethics law or warrant further review, and that this complaint be dismissed. Thank you.
Thank you. And I echo your comments as well. Andrew and Dan. You go by Dan or Daniel?
It's fine.
Okay, great. Thank you. See no comments on the motion. We'll call for the vote.
Commissioner Hollister,
Aye.
Commissioner Newell,
Aye.
Commissioner Mason,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Burke. Thumbs up. Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passes 9-0.
Thank you. We did have an agenda item added to our agenda. Thank you yesterday, maybe.
Chair Lindsay.
Oh,
You have to do separate files for this.